Respected Professor Basavaraju sir, respected Sri Muralidharan, dear coordinator of LJRF, Chintu Joseph, coordinators of Mandava Science Congress, then dear students and all participants. I have been listening to the speech of Professor Basavaraju, which has enlightened us much on this Independence Day. I too wish to confer on you the 75th Independence Day wishes at this juncture. What I want to talk about to you at this point of time is the vision of Ambedkar on social justice and democracy. I think that this should go hand in hand. What is social justice with respect to Indian democracy? And you all know that social justice is a relative concept because it will vary with the circumstances, isn't it? The determinants of social justice will vary with the circumstances. So what is required for achieving social justice is that individuals should be given full opportunity to develop their capacities. And the state shall ensure if all individuals are getting that opportunity, whether maximum number is enjoying that opportunity. So for that, the state shall have to remove all sorts of disabilities. As earlier speaker has pointed out, all disabilities with respect to caste, with respect to sex, then race, creed, religion, nationality. So what the state shall do is to provide opportunity in a positive way so as to develop the faculties of individuals for the sake of progress of the society. So that is what is meant by social justice in a general way. So where has this social justice been mentioned? What is the importance of this social justice? Our makers were very much concerned with social justice, particularly in a democracy like India. So we know that our constitution starts with the resolve by the people to make or to give for themselves a sovereign, socialist, secular, democratic republic, and to give to them and to secure to them justice, social, economic, and political. So there comes social justice. So what we require is justice, which is social, economic, and political. Where have we gone for political justice in a democracy? When we have attained freedom, we went for political democracy, where we never wish to install a permanent dictatorship in no manner whatsoever. So we went for a political democracy. So we don't want to stop with mere political democracy. We don't want the holders of political democracy to grab power and enjoy power. So what we wanted at that instance was that we will have to lay before them our ideal, which we considered as economic democracy. So when you say justice, social, economic, and political, we mean democracy as well. That is social, economic, and political democracy. Then where have we attained this economic democracy? And we haven't attained economic democracy fully through the fundamental rights and the basic principles that is embedded in the preamble. We have gone to, or we have embedded, or we have found all this in one of the most important directive principles, that is in Article 38, where the state was given a directive to strive to promote the welfare of the people and for securing and promoting as effectively as it can, as effectively as it can, a social order in which justice, social, economic, and political democracy can strive. So it is in that context where economic democracy gains importance. So it's for the state to establish a social order in which the principles of the justice, in which the principles of justice, social, economic, and political shall inform all the institutions of national life. So this can strive only if it is informed very well, only if it is implemented properly. So that is where the duty of the state is vested, to establish a social order in which justice, social, economic, and political shall inform all the institutions of national life. So that has to be laid before the people who had formed government, because they had to go with that. And we know that fundamentally, if we want to establish justice, social, economic, and political, we'll have to go back to the electorate, isn't it? So mostly we can say that ours is mostly a political democracy, because we still rely on one man, one vote. Because even though for establishing economic democracy, if we lay before the people our ideal of economic democracy, to establish a social order in which justice, in which justice, social, economic, and political can strive, the makers or the one who is in governance can do is to go ultimately to the electorate. So that is going back to one man, one vote itself, which is political democracy. So that's the concept of social justice and democracy. Whenever we want to establish, wherever we find the need for social justice, we'll have to go back to the people. So you can say that this is an attribute of popular will or the sovereignty of the people. It comes from the sovereignty or the will of the people. So where is vested the mandate for achieving social justice? So it lay with the people itself. So they will have to find out good persons to come to the assembly, good persons to come to the cabinet. Then only can we establish justice, social, economic, and political in a very effective way. So that is what is happening with respect to a constitution. So when Ambedkar was in assembly, when he was speaking about social justice, he asserted the word strive in the context of the directive principle. He held that the directive principle is more important than fundamental rights, and he asserted that the word strive should be used. That is, the state shall strive to establish a social order in which justice, social, economic, and political shall inform all the institutions of national life. Why has he asserted for such a word? Because he knows that blockades will come in, hurdles will come in. No government should go back saying that we are not in a position to achieve social justice. So what he wanted was that the government should not, should not be declined to, establish or to, absorb the norm of social justice and to establish social justice in governance. So that is what the word, when he said the word strive should be inserted, that is what he meant. Because we know that many hurdles will come. We say that the situation is not good now. The government can say that the situation is good now to implement, the social order as is required as per Article 38 of the Constitution. It can also say that it's not fair because there are financial constraints. So they can go back saying that it's not a good situation, or else they can say that there are certain financial restraints, so we can't implement such a social order as is per se under Article 38 of the Constitution. So he doesn't want the government to say that. So the word strive was what mandatorily included in the article to make the government duty bound to establish such justice, that is justice, social, economic, and political in all walks of life, in all institutions, has to be informed to all institutions that such a justice shall be established. So next is equality of status and opportunity. We can call this principles of justice, liberty, and equality as the Trinity, because only if these three are achieved, that is, when we say we have equality of status and opportunity, we will also be achieving the liberty, isn't it? When we acquire the equality of status and opportunity, we will automatically be acquiring the liberty of freedom and expression and of belief, faith, and worship. And we will, then we will be leading to our, our position will be leading to justice, social, economic, and political automatically. So we can say these three principles as Trinity, and many things can be absolved through bringing in or achieving this Trinity, these three principles, that is justice, liberty, and equality. You know that what happened in S.R. Bommai case. In S.R. Bommai case, it was held that secularism was one of the basic features of the Constitution. And it was also held that it is forming part of the basic structure. That's a preamble. The point, the principle of secularism that was inserted in the preamble was forming part of the basic structure. So what was held was that this should be harmonized so as to achieve the trinity, that is equality of status and opportunity, and thereby leading to liberty, and thereby leading to justice. And with this trinity in operation, we can also say that along with dignity, a person can achieve the entire, the entire right to life concept in his days ahead. So if we have the right to equality, if we have the right to liberty, we'll naturally be achieving justice. Then we'll also be achieving the dignity, which is a very basic part of individualism. And also we can go for fraternity, and thereby we can go for fraternity, which is very closest to democracy. Even we can call it as the very closest element of democracy. Once we have achieved justice, we can go for fraternity. It's a very closest element of democracy. When I say that, after democracy, we can go to unity and integrity of the nation. So that is how these principles were, listed and included in the preamble of the Constitution. Why has these principles been given so much importance? Because ours was a democracy. Ambedkar didn't go for a parliamentary democracy. He has actually went for a constitutional democracy where the entire principles of constitutionalism should be respected. That's why all these principles were given importance. Then if we can say, go to the Sabarimala verdict, since many of the principles have been explained by Basavaraj sir, I can inform you I can discuss with you some of the important judgments of the Supreme Court to make you aware of these principles. That is Sabarimala verdict. What happened in Sabarimala verdict? In Sabarimala verdict, the women were denied entry. The women in the age group 10 to 50 were barred from entering into the temple. They were banned entry into the temple. Under Kerala Hindu public places worship authorization of entry rules. So what happened was that through rules, these women were denied equality of status and opportunity as equally as that of man. A woman was denied equality equally as that of a man in the case of her entry into the temple, because she belonged to the age group 10 to 50. That's not a reasonable restriction, isn't it? That's not a reasonable classification. So that is actually affecting the equality of status and opportunity. And that is indeed affecting her, her right to right against untouchability. She's put to untouchability. She's put to the abuses of untouchability. If somebody is restricted from entry into temple, we can say that they are practicing untouchability. And also we can say she is denied a right to freedom of religion, isn't it? Once we have free conscience, we have the freedom to propagate, freedom to profess, propagate, and practice religion. We'll be enjoying a right to religion in full. But there she is denied a right to freedom of religion. And also she is ultimately denied a right to movement. Even you can say she is denied a movement to the temple. So her fundamental rights are denied, as well as a right to life. That is a part of her dignity. Right to live with that is right to live with dignity and with liberty. Her right to live with dignity and liberty is getting, affected by her ban to enter the temple. So what has happened here is that the court held that women should be given equality of status and opportunity in the case of entry of temple, and therefore this rule was held unconstitutional as per principles of Article 14. Article 14 says about equality before law and equal protection of law. When do you say that there is equality before law? Only if all are placed at the same level, we can say there is equality before law. Then only we can say all are provided equality, isn't it? So equality before law and equal protection. If one has to get equal protection, he has to be placed at par with others. So the first position to be achieved is equality before law. So to gain equality before law, the particular worshipper, the woman worshipper, has to be placed at par with the man worshipper, isn't it? The male worshipper. So once she is placed in equal status or in equal, if she is given equal opportunity, then she will get equal protection of law. So that is what is actually what is mandated by Article 14 of the Constitution. When we say equality before law, we mean equality. First of all, we mean equality before law. All are equals. All are to be made equals before law. Then only we can provide them equal protection. So there is an infringement of Article 14. The court found that there is an infringement of Article 14. Then Article 15, that is, there was prohibition on the basis of sex, isn't it? So there was a prohibition of there was an infringement of Article 15 due to violation of prohibition of discrimination on the basis of sex. Then there was also a matter of untouchability. That was also a matter of untouchability. So it was also a violation of Article 17. Then Article 21, her right to life, right to live with dignity and with personal liberty, that was also denied. And finally, her right to freedom of religion, that was also denied. So that was what happened in Sabarimala verdict. So when these principles, when I say liberty, equality, and justice is achieved, we can directly achieve the other fundamental tenets, isn't it? We are led to the other basic tenets of the Constitution. We can go for unity and integrity, and we say that a woman's right is violated when she is denied a right. Actually, her peace, progress, and development is harnessed, isn't it? It is blocked. And thereby what happened is that the development of the society in turn is getting affected, isn't it? When a woman's progress is blocked, when a right to live with peace is, is affected, when a right to, when a right to life, when a right to live with peace, progress, and through that her development is affected, that is in turn affecting the development of the society. So whenever violation takes place in any manner, any sort of discrimination can affect the right to life, liberty, equality, security, then right against exploitation, and ultimately right to life of a person. So that has to be prevented. And so all these principles inserted into our Constitution, and Ambedkar stood for that. When I said that all are to be considered, first of all, what we require is equality before the law. What he said is that when we go for positive actions, we call it affirmative action. When we go for affirmative action, what we require is that, first of all, those who have not still entered into the public sphere has to be brought up, isn't it? Has to be uplifted. So that is what is happening in the case of reservation. So those who have not attended public services, they have to be brought in first into the public services through giving them reservation. Then only we can say that they have achieved equal protection of law. So first of all, what we require is equality before law. Then only we can enjoy equal protection of law. So reservation is permissible under law because of that reason. What is affected is our right to equality. That is, equality before law is affected because we are denied of an opportunity to enter into public services. So those communities who were denied of the opportunity to enter into public services were first of all given reservation, and they were uplifted at par with the other community, uplifted and brought at par with the other communities. And thereafter, the law was applied and they were given, provided with equality. So that is what is happening, what we have seen in Chaira Banu case. In Chaira Banu case, the triple talaq, which was irrevocable and instantaneous, was held to be violative of all these elements, isn't it? Or a man can promulgate triple talaq. Why can't a woman be made to suffer? So personal laws are conferring inferior status upon woman and thereby violating all fundamental rights that she should enjoy under the Constitution. So that is what happened in triple talaq case. A man promulgating instantaneously talaq 3 times, a woman is left destitute. So woman is denied all her rights, all her fundamental, her right to life. Then there also she is denied of a right to equality, where a man is such a right under the right to promulgate triple talaq, offer triple talaq. The woman is not given an equal, an equal status, isn't it, as that of a man. So whenever she is ousted out of the marital relationship, she is not getting any remedy. So what has happened is that the Muslim women right on marriage act was passed as a consequence of this decision, because here her right to equality was seen affected, her right to prohibition of discrimination on the basis of her prohibition of discrimination on the basis of sex was seen affected, her right untouchability, then her right to life was seen affected in the Article 21, her right under 25 was seen affected, where she was unable to profess her religion in accordance with the Shariat law. So application of Shariat law 1937 Act is there. As per Shariat law 2, that is as per the cultural rights too, triple talaq is violative. So that was also seen affected. That is under Article 29. So, and under 26, the Muslim community was prevented from blocking the man, from stopping the man from promulgating triple talaq. So 26(1) was also seen affected. So these are the different provisions that are denying woman, or we can say any person of her or his fundamental rights that is inscribed in the preamble and in the other basic principles of the Constitution. So we'll have to see whether all these are met with. Then only we can say we have achieved equality, or we have achieved the full freedom, social justice. That's what I said. Social justice encompasses economic democracy and social democracy. And for that, we'll have to go for the, what do you say, ultimately, what we can understand is that we are ultimately going to one man, one vote scenario. So for achieving all these objectives, to promulgate suitable, to enact suitable legislations, we'll have to go back to political democracy. So we have political democracy, but to achieve social justice, no type of polity is mentioned clearly in the Constitution. It's not mentioned specifically, because the Constitution never says that for achieving social justice, such and such polity is required, or such and such form of government is required. That's not mentioned in our Constitution. So what we require is to make our government, or the government one who is in governance about the fundamental rights, and then make them understand what is happening and enact law and put it into practice, implement it suitably. So that is what happened in Shaira Banu case. And when I say gender neutral, when I say gender equality, it's also a facet of right to equality. We have very recently gone to the lesbian, bisexual, transgender rights, queer community, queer, intersexual, then asexual community right, that is LGBTQAI plus rights. So when we go to those community, we can say that a gender neutral stand is not taken in the case of transgenders, lesbians, gay, queer people like groups. When heterosexuals are allowed to live as couples, these people are not allowed to live. Society is still has not yet changed, isn't it? So their state has to take step. So there comes the importance of social justice, where state has to secure for promoting the welfare of the people, social order, so as to facilitate justice, social, economic, and political, and to inform all institutions of the mandate, all institutions of national life to observe the mandate. So all these institutions are to be, mandated to observe justice, social, economic, and political. Then only can we protect the rights of such communities like LGBTQAI groups, then like minorities, as I have said, Muslim community, then about the reservation that we are enjoying now. We can say that in Indira Sani case, the creamy layer concept came, but later the court has accepted many other principles like carry forward rule, the seniority in promotion that is seniority in promotion, reservation in promotion, consequential seniority rule has been accepted by the court. The court held that it's not at all a denial of equality, because that can be given provided it's not violating the quota. Only if it exceeds the quota, that can be held to be violative of right to equality. So all these are giving us the vision that social justice has to be maintained, and it has to be suitably maintained irrespective of the system of government. Since we have a democracy, every time we can go back to the mandate of political democracy, that is one man, one vote, where we can say that the directive principle actually derives its power from the popular will or the sovereignty, the popular sovereignty. So there comes the importance of constitutional democracy in India. And Ambedkar has really gone for constitutional democracy. It's not parliamentary democracy as in Britain that we have envisaged for. So with these words, I conclude my speech, and I'm sure that you'll be going into more aspects regarding social justice. You can definitely go into this. Will be a lead for you to go into further aspects on social justice and Indian democracy. Thank you. Thank you.